in broad strokes, what I'm interested in as the biography that Daphne outlined kind of telegraphs, is basically thinking about the role of human judgment in a world that's going to be kind of increasingly mediated by and perhaps even more firmly sort of controlled by automated and other kinds of machine-based decision-making systems. So at least in the United States, it's pretty commonplace in lots of jurisdictions now to have risk prediction algorithms be part of pretrial detention decisions and sentencing decisions. It's pretty common for police departments to use predictive analytics to make deployment decisions about where they send patrol units and basically what kinds of crime patterns they want to focus their attention on. It's pretty common for bureaucratic agencies like Social Security administrations and various parts of the immigration system to rely on algorithmic profiles, essentially, in terms of triaging cases and diverting them to the right parts of the bureaucracy. And so, these developments are kind of going on, worldwide now, at least in the developed world, and they're only going to intensify. And the trend line basically seems to be one in which an increasing share of decisions that were sort of formerly entrusted to human experts of some kind. And expertise has a wide range. It can be, deep expertise that requires a long time to cultivate and a real kind of specialized skill set, or it can be like the expertise of a bureaucrat is not necessarily all that hard to come by, but it is nevertheless kind of in a contextual way a form of expertise. That the questions that have been traditionally entrusted to human expertise are instead going to be delegated in whole or in part to powerful machines that are capable of processing a sufficient volume of historical data that they can basically sort of resolve individual cases according to complex historical patterns at a rate that is sort of much more efficient in terms of the marginal cost of decision making, and often more accurate in terms of the minimization of type 1 and type 2 errors than the human expert version of the same decision. And there's been a lot of work on some of the concerns that really sort of attend to the design of algorithmic or kind of powerful machine learning-based decision-making systems. I'm sure many of you in the audience are familiar with the kind of burgeoning conversation around the problem of what's often referred to as bias in, bias out, or sort of the replication of discriminatory or disparate patterns historically through the use of historical data sets. So, in the criminal justice space, which is where I tend to kind of live and work, this problem is, very easy to see in the sense that, if you're trying to say, predict the risk that a given defendant is going to recidivate, that they're going to commit another crime, or you're trying to predict where crime is going to be in terms of which neighborhoods or which people in a social network are likely to commit crimes. Well, all of those predictions are going to be tracking, they're only going to be as good as the historical data sets that inform them, and the historical data sets that inform them are going to be in large measure from the law enforcement system itself, or maybe law enforcement records plus a whole bunch of other data. And of course, when the law enforcement system has historically been biased in different ways, or has involved in its application many different kinds of disparity, including most obviously kind of racial disparities in the US, then those patterns are going to be picked up in the machine systems going forward. And so there's a concern that the machine systems are maybe not only going to replicate historical patterns, they might move beyond them in some ways, but that there's going to be a kind of a positive feedback loop vis-a-vis historical patterns. So that's a really important set of debates, one that I've been involved in to some extent, but but I'm actually interested in a slightly different kind of adjacent question, which is, even if we could imagine as a matter of sort of normative theory and then corresponding data science, um, solving for the kind of bias in, bias out, or sort of discriminatory algorithm problem. So even if we could imagine machine systems that were designed on purpose to kind of overcome that problem or to mitigate it, such that machine decision making through time became less biased and relative to human expert judgment, perhaps even quite a bit less biased, or sort of favorable on sort of discrimination or historical equality grounds. Is there something that would nevertheless be kind of missing in a world where we delegated really important decision making to machines? Is there something about human judgment as a kind of a faculty or a cognitive process or a vehicle for moral sentiment, or there's different ways to talk about it and we'll get into it today, but is there something about human judgment as a process that seems to kind of resist automation in whole or in part? So is there something about what humans do when they make decisions, particularly normatively tinged decisions, that just can't really be fully replicated by an automated system, however powerful it may be? That's the question that has been preoccupying me. And so one so if that's the question, sort of what about human judgment seems to be sort of insusceptible all the way down to an automated substitute or machine-based substitute? I think there's kind of two ways to think about answering that question, or there are two sort of distinct types of reasons why we might be skeptical that human judgment is susceptible to automation, or put the other way around, two different kinds of reasons why we might think that there's something kind of special or irreplaceable about human judgment. So one kind of reason, which I'll just put my cards on the table, I think is not going to be the winning reason at the end of the day, or in the end. But one kind of reason, which has gotten a little bit of traction and folks are sort of talking about now, is that there's something about the ability of humans in exercising and using the kind of the hardware of the human brain with the inputs of all sort of historical experience, individual and collective, that inform human judgment, that sort of equip us as moral and epistemic agents to make judgments in the world. There's something about that is capable, at least in some cases, of generating better results. So humans will be able to get at least certain kinds of cases right in a way that machines may not be able to, or at least there's reason in principle to think so. An argument along these lines might be something like, look, machines are going to be really good at canvassing cases that kind of track aggregate patterns, or cases that look like the normal case or the median case, even if it's not a perfect exemplar case, but is kind of near the exemplar or near the median. Machines are going to be really, really good at cases that are kind of normal in that sense, even if the category of a normal case is a sort of a broad variegated one. The idea is like, look, if the case is of the kind that the decision-making system has been designed to resolve, then machines performing aggregate analysis, at again a kind of a lower cost and much higher volume rate than a human ever could, is going to be probably ultimately the better decision-making vehicle. However, this is where the argument goes. Excuse me. Or at least this is one version of the argument. However, when you have a real outlier case, when you have a true edge case, something that's genuinely different from a historical pattern and a little bit weird in whatever way, that's where human judgment is going to be kind of better, even in principle, or there's grounds to think that sort of even under very, very kind of projecting into the future, powerful technological conditions, that human judgment will be able to identify and resolve outlier cases better than a machine system will be able to. So to take a concrete example of this to sort of flesh out this form of argument, you might say, some of you are probably familiar with efforts to sort of train machine learning algorithms to recognize visual patterns. So can you get a machine to figure out if something is a picture of a flower, let's say? Well, the machine, it turns out, at least under current technological conditions, we can get machines to be really, really good at this. If you're trying to recognize, let's say, like a dandelion or a rose or something, right? We get the machine to be really, really good at it, except there's always going to be a margin of cases where something looks so much like a rose or a dandelion from the machine perspective, but from a human perspective, it's obvious that it's not a flower. And the idea is that because of the sort of outlier quality of these cases, the machine might be really good if you just randomly pulled images off of Google or something and put it in front of the machine and said, is this a flower or not? The machine's going to have a really, really high precision recall rate, right? Very few type 1 or type 2 errors, except in these marginal outlier cases, which are the cases that the human sort of can intervene in and say, yeah, I see why the machine might have thought that was a rose, but in fact, that was a picture of a fire truck, taken at a particular angle. Or I could see why the machine thought that was a dandelion, but in fact, that was a road sign, or whatever. And so the idea is that, in the flower case, it's trivial. It's sort of I don't know why we would care about that function, but maybe if we cared about that function for some reason, we might just decide that we're okay with the machine system because of the efficiency gain and because they're going to get 99.999% of cases right, and the ones that they don't get right, whatever, the human system's going to make a lot of errors too, and so on net, we're just okay with the machines. But in more sensitive contexts, like deciding how long somebody deserves to be incarcerated, or deciding, who gets to, remain in the country they call home rather than being forcibly removed, or, anything that sort of has the usual indicia of a sort of a due process problem, the kind of gravity, exercises of violence, draconian penalties, that sort of thing. When we're in those realms, we do care about outlier cases. And the role then for human judgment, at least at a minimum, maybe we want a bigger role for human judgment, but at a minimum, the part of human judgment that is not going to be automatable away, why we wouldn't want to turn over the reins of the system to a machine, is to identify those outliers and make sure that they're being sort of disposed of justly. Okay, so that argument has lots of, that's just one example of the kind of argument that would focus on human decision-making or human judgment yielding better results than the machine equivalent. But by category, this is a familiar idea, and it's one that has gotten a fair amount of airtime relatively recently. And the idea, again, is that there's something about human judgment as a kind of information processing mechanism that is able to just capture and better resolve certain categories of cases, even in principle, even if the machines were really, really powerful, than a machine could do. So that's one way of sort of thinking about what might be special or important about human judgment. The second way, which is what I'm going to talk more about today, is thinking of not so much about the content of the judgment or the result of the decision, but instead thinking about some kind of normative feature of the decision-making process that makes human judgment a kind of necessary ingredient to that decision-making process, regardless of what the results are, regardless of what the content of the judgment ultimately is. So one idea along these lines I've developed in a recent paper, and this is what Marcus circulated, I think, so some of you in the audience have seen it, is an argument that there's an idea that kind of follows from first principles of democratic theory. So it's a sort of political theory idea of role reversibility as between the party who is exercising judgment and the party who is affected by the judgment. And the idea here is that, look, regardless of what the judgment is, whether it's guilty or innocent, whether it's harsh or lenient, whether it's the case goes in this category or that category or whatever, that the fact that the party who is subject to the judgment and the potential adverse consequences that follow from the judgment is in principle reversible with, or kind of could have their positions sort of swapped with the party who is charged with making the judgment. So the judge and the affected party, or the juror and the defendant, or there's different sort of paradigmatic examples of this, but the one who kind of, holds the sword, or sort of holds the reins of the apparatus of power, and the one who is subject to its operation, that those two parties could, in a slightly different counterfactual world, they could be switched. So the judge or the juror who is exercising, or who is deciding whether the use of state violence in a purposive way that we would refer to as criminal punishment is warranted in a given case, that they too could be subject to that state violence had they committed the same offense, or had the facts been all the same, except that they're the one in the defendant's chair, not the one in the seat of judgment. So the idea here is that by contrast to accounts that would want to talk about human judgment as a safeguard of kind of better resolution of cases, or of the sort of substance of judgment, or the content of judgment, this is really about the structural sort of features of the decision-making environment, and specifically about the kind of fundamental equality and fungibility of persons. So in the paper, we tie this to a political theory tradition that I think is most prominently associated with John Rawls, but you could find, and we explore a few other kind of parallels. There are ways to understand sort of Kantian morality along these lines too, but the basic intuition and the way in which it's connected to democratic sort of governance and sort of self-governance as an ideal is the idea that we are all kind of co-equal, and that when even in moments where we've decided to exercise judgment, or where one of us or some group of us is called upon as co-equal members of a polity to stand in judgment of another, that we are in some sense also judging ourselves counterfactually. That all judgments are things that we are willing, in the same way that Rawls would say that we're on burden when we design kind of legal systems, or when we design rules and regulations at the sort of legislative and administrative level. The right way to think about that is, would we be willing to do this to everyone, or would I be willing to commit to a world in which these rules obtain, even if I didn't know what position I was going to be in? So too with individual acts of judgment, we should sort of have this role reversibility, structural kind of equality principle in place that allows judgment to be imagined as something that we are kind of imposing upon ourselves, or that we would be willing to be subject to if we were in the opposite role. And likewise, that the person who is in the role of receiving potentially adverse treatment on the basis of a negative judgment, like a defendant, a criminal defendant, can then sort of account for what has happened in a way that imagines themselves as they might have been had the roles been reversed and they were in the jury box. So there's a way in which the account here of criminal adjudication, or of a conviction, would be one in which, beyond a reasonable doubt, to convict is essentially to say that the defendant, him or herself, had they been in the jury box, would have convicted, having seen the facts presented in this way. Okay, so that was the idea that we developed in this paper, and my sense is that that this notion of role reversibility is a sort of sturdier basis, and I think a kind of clarifying basis on which to argue in favor of certain aspects of human judgment being kind of insusceptible to automation, because it really has to do just like democratic sort of precepts have in other contexts, long before powerful machines, have always kind of had to do with a sense of self-rule. So ultimately, what grounds the legitimacy, or at any rate, what's a necessary condition of legitimacy, is the sense that law and exercises of state violence are something that we do to ourselves. That's the kind of core axiom, as I would articulate it, of liberal democracy. And that in the same way, we draw an analogy in this paper to caste systems and to kind of colonial or imperial rule, that like in the same way that we can recognize that there may well be imperial structures or caste systems or other kinds of rigid stratification that are illiberal or kind of anti-democratic, that are still pretty just. They still are pretty good at delivering the right results in lots of cases, or in coming to the right sort of distributive equilibria in terms of benefits and liabilities within a social order, allocative efficiency, et cetera, that at some level, it doesn't matter, right? You can't defend an imperial regime on the ground, at least if one is a Democrat, a small d Democrat, you can't defend an imperial regime on the ground that it tends to produce really good results. You're going to have to say something more about how it might be reimaginable as a kind of mechanism of self-rule, or there may be kind of less daylight than we like to think between democratic structures and imperial or kind of more fundamentally hierarchical structures. And indeed, even within democratic contexts, often the claim of, typically takes place on the fringes politically, but there's always an opportunity to make a claim that this looks democratic, or formally it's democratic, like everyone went to the ballot box and, there's public accountability, but in fact, this is being experienced as a kind of imperial rule domestically, right? A rule from without, rule by elites, rule by others, plutocracy, et cetera, et cetera. The variations on that kind of move are infinite, but the idea is that I think it comes back to some notion that this role reversibility idea has been violated, and that the same is true with machine rule. So I would say that the right analogy to think about what sort of rule by machines, even when they're really powerful and really efficient and really good at coming to the right results in the aggregate, that the right analogy is not, to just like the machines are basically implementation tools and they're basically just like an administrative bureaucracy of the kind that we're all used to. The right analogy is to an imperial structure. The right analogy is to a sort of a rule, from the metropole, from far away, and it has all the usual infirmities. Okay, so that's the idea that I was exploring in this previous paper. And what I want to talk to you about here for a couple more minutes today is it is an extension of the same core idea, but that moves in a slightly different direction, or you might say tries out a different form of the human judgment is important and insusceptible to automation argument, not on results grounds, but on kind of process grounds, but in a slightly different way. This new argument sort of picks up where the previous paper left off, and that it's trying to think about what the sense of sort of co-equality and role reversibility is between the party exercising judgment and the party undergoing judgment sort of means, and why it matters. So one thing it can mean, or why it matters, as I was just describing, is simply that we might see it as an instantiation of a democratic ideal, and that its absence likewise would be an instantiation of a kind of imperial alternative to democracy. And so on that basis alone, in terms of just what about the power structure it reflects, or what about the political world it sort of reflects, will become, the basis on which to kind of lionize human judgment in this role reversible fashion. What I'm exploring in this new paper is what sort of process of judgment the role reversibility ideal, or the kind of the democratic co-equality ideal as between human beings, may enable. What kind of judgment that is distinct from focusing on the results of judgment, but is but is also slightly different from just the claim that it is an instantiation of sort of democratic precepts. And specifically, I'm interested in moments in our institutional and in everyday kind of moral, so institutional legal lives and everyday moral lives, when in response to the possibility of exercising judgment regarding another person's actions or choices, we feel like the proper response as moral agents is to decline to judge. So not to be lenient in the sense of let them off the hook or acquit them or say that what they did was okay, but instead to sort of take a step back and decide that that we lack grounds to actually render judgment. It's something about the situation and something about the specific kind of moral psychological world that the case calls forth for the person in the seat of judgment makes it so that judgment seems unwarranted one way or the other. So I'll unpack this a little more in the abstract by kind of talking through what I take to be its kind of theological paradigm case, which is the parable from John 8 about casting stones, or Christ's admonition to those who would cast stones against a sinner, that they should consider their own position before they do so. And lo and behold, once they do that, everyone sort of puts their stones down instead of exercising judgment or punishment. And then I'll talk about some more concrete examples from the legal system. So, the core idea here is basically that, if we think about that story, so what happens in that story, for those of you, you may have sort of learned about it, in your own religious education, or just through sort of cultural lore, or, even just, heard about it by other means. But basically, Christ is causing a lot of headaches for the power structure in Rome, to put it mildly. And one of Christ's main sort of calls to his followers is to sort of move, beyond the law, or to kind of recognize a distinction between human authority and divine authority, and to prioritize divine authority, which of course causes a lot of problems for those who are in the position of human authority and wish to remain so. So the backdrop of the story is that a number of the Pharisees, basically sort of Christ's critics, come and they've dragged a sinner to the town square, an adulteress, and the punishment pretty clearly, like we'd say in the law, sort of as a matter of the plain text of the statute, as it were, or the sort of the clear command of the law is that adultery is punishable by death. So it's a capital offense, and there's really no dispute that this person has committed adultery. And so the reason why the Pharisees have sort of brought this to Christ's attention is because they want to basically embarrass Christ's moral position, or his kind of antinomian position that human law isn't worth a whole heck of a lot and that divine authority is the more important thing. And the way they're going to do this is they're going to say, look, Christ, what do you do in this case? It's one thing to say, look, we want to move toward a world where we have better laws, or where we don't need laws anymore. But here's a case where somebody has committed adultery and the law is really clear. So what are you going to do? What are you going to say? You say that the law doesn't apply? Are you going to say that, capital punishment is warranted? What are you going to do? So it's a kind of it's supposed to be a gotcha moment. So what does Christ do? He says, well, first he says nothing. He kind of pretends like he doesn't hear what's been said. And when pressed, he says, all right, I'll tell you what. Everyone who came here with a stone to cast against this person, to basically, it's a collective flagellation ritual. That's the mechanism of capital punishment. You're going to throw stones at this person. Everyone who came in with a stone, think about if you've ever sinned, right? Think about your own moral position, introspect at a kind of moral level as a moral agent, and decide whether you feel warranted in carrying out this execution ritual now. And then everyone, lo and behold, once they go through this cognitive process, they famously put down their stones. They decline to cast the stones. They all walk away. And then Christ turns to the sinner and he says, oh, I see that nobody is here to cast stones against you. They've all walked away, and I too, decline to judge, or I too sort of refuse to cast stones, and so you're free to go. So it seems to me that what's powerful, what's so powerful about this parable, and the reason why it seems like a valuable kind of lodestar for thinking about human judgment, is that Christ is not asking the sinners, or I'm sorry, not the sinners, the onlookers, to regard the sinner's case differently than they otherwise might. So we have a rich tradition in our legal institutions that I think reaches back to Aristotle and maybe further, that we would think of as the equity tradition, that would say, look, rules are really coarse, rules are really crude, they're designed to work at a level of generality that necessarily generalizes, and so is going to suppress some of the underlying complexity of particular cases. That's the point of a rule. And so what do we do when we're confronted with a case like I was describing a few minutes ago? You might call an outlier case, a case that doesn't really seem to fit within the four corners of the rule, or even at the kind of outer edges of the rule, but instead seems to sort of, only fall into the rules category as a formal matter, but in an underlying way seems not to fit. What do? We make equitable adjustments, and we have mechanisms in the law to do this. Literally, courts of equity used to do this. Equitable remedies do this. There's all kinds of other mechanisms, even if they're not labeled as equity, that do this, right? There are kind of fine-grained adjustments, right? Somebody's, let's say, been convicted of a crime. Well, from there, the judge is going to have a lot of discretion to engage in a sentencing analysis that attends to mitigating and aggravating factors, and is basically trying to come up with a more granular analysis than just yes, no, were they guilty, right? We have all kinds of tools to do this, to particularize and further refine judgments. And obviously this is part of our everyday moral lives too, right? If we're having a debate about someone, like we just had a debate in the United States, it's a prolonged public debate about whether this kid in Wisconsin who decided to become a vigilante and ended up killing a number of people, was sort of guilty, and why, and or if he's justified, and so why, and in the process of trying to come up with a coherent sort of explanation of that for ourselves and collectively, we naturally gravitate toward, or at least one kind of aspect of the debate is always going to be, is your analysis sufficiently granular, right? You want to apply rules. Moral systems, legal systems are built on rules at some level, but we need to have case-specific adjustment. Okay, but that is not what Christ is telling the onlookers to do, right? He's not saying, look, yes, she committed adultery, but here's some mitigating facts. Or yes, she committed adultery, but once you hear her side of the story, you'll see that it was excused in some way, or she was operating under duress, or whatever, any number of things that might be specific to the case and make the judgment more particularized in the favor of what we would call in contemporary terms an acquittal. So it's like, yes, she looks guilty in the same way that somebody who acted in self-defense. Did they, formally speaking, use violent force on purpose against another person? Yes, but nevertheless, we have this case-specific, highly particularized contextual mechanism for figuring out whether an adverse judgment is actually warranted in their case. That's not what Christ is asking for. Nor is he saying that you should exercise mercy or sort of forbearance against you, or toward this person, in the sense that, yeah, they're guilty, but for some kind of reason based on pity or compassion, or something about their case, a great pathos of it. Let's say the sinner has lots of young children and they're going to go hungry if the sinner is put to death or whatever, right? It's not that either. It's not about, okay, you have good grounds to judge, absolutely, and once we apply all the equitable adjustments, in fact, harsh judgment is warranted here, in the sense that the right application of the right sufficiently granular rule system would be one that yielded judgment in this case, or yielded adverse judgment, but nevertheless, you should sort of forbear upon that judgment, or you should treat the sinner to a less harsh punishment in practice than you would be justified in treating them to in principle. No, it's not that either. It's instead, by contrast to both of those models, and there's a very rich tradition of thinking about the relationship between equity and mercy as it surfaces in the law and elsewhere. A lot of very interesting, philosophy and legal theory on that question. But by contrast to both of those models, what Christ, I think, is asking the onlookers to do is perform a different kind of cognitive operation, one that is about introspection and about considering whether they have grounds to exercise judgment in the first instance. So it's not make your judgment more granular, nor is it, okay, harsh judgment is warranted, but here are some countervailing reasons why you might not want to carry through on the implementation of the penalty. But instead, do you have grounds to judge at all? Do you have grounds to judge at all? We can see this contrast, especially from mercy, in the way that the parable continues once the onlookers have put down their stones and gone away, and Christ then turns to the adulteress and says, I see that none of your fellow men are willing to, cast a stone against you. I too, refuse. But when Christ refuses, that sounds more in mercy. That sounds more in, as a divine figure, I am capable of judging. But as, at least in the Christian tradition, we've sort of long associated with divinity, there's a sense in which the merciful attitude of the divine is one of the constitutive features of divinity, and that God judges, but it also has the capacity to forgive or forbear. And it's appropriate, at least arguably, at least more appropriate than it would be with the human onlookers, for Christ to be in the merciful mode, because Christ is, after all, differently situated. For the human onlookers, though, the merciful mode is not only not what Christ is calling upon them to sort of channel, but indeed might itself be somewhat inappropriate in the sense that as co-equal members of the social order, right? The question that Christ is sort of calling their attention to is whether, in reverse, they would have done the same thing, or whether they have the requisite moral position to engage in judgment. And what this, the answer isn't necessarily that they don't have the requisite foundation for engaging in the judgment. That's what happens to be the case in the story. But it's perfectly possible that somebody kind of heeding this admonition, if they were a saintly person or sort of morally righteous type who had not sinned in their life, they might well say, yeah, I've thought this through and I do have grounds to judge. I feel like judgment is warranted here. But the point is that you have to go through this kind of threshold step in deciding whether to exercise judgment in the first instance. So there's a rough analogy in terms of legal categories here between what lawyers would refer to as the jurisdictional question and then the merits question. So, courts, when they decide whether they're going to resolve a case or how they're going to resolve a case, need to assure themselves that they have jurisdiction over the case in the first instance. That's kind of the backdrop of all law. Now, in many cases, it will be uncontroversial. Nobody will be disputing it. But the court's sort of always on burden to explain or assure itself that it has jurisdiction. That's one heuristical way, at least, of understanding the claim I'm making here, that there's some sense in which, as moral agents, and then as kind of members of a social order called on instrumentally in certain institutional capacities, like on a jury trial or whatever, to exercise legal judgment, not just moral judgment. Either way, there's some sense that we should be on burden to evaluate whether the grounds exist at all. Okay, and so the reason why I think this is at least plausibly a way of thinking about what is kind of non-automatable about human judgment is that it seems like, or the sort of intuition I'm exploring in this new project, and I am really looking forward to hearing people's thoughts and questions about it, is the idea that basically deciding whether you have good grounds to exercise judgment, whatever the results of the judgment, whether harsh or lenient, on an all things considered analysis using all the normal sort of tools of judgment, the application of rules, subject to equitable adjustment, subject to potential sort of mercy or other forbearance mechanisms, et cetera, right? The complexities that always attend to what the right judgment is in the case. Before you get there, you have to figure out whether it is warranted to exercise judgment at all, or instead to abstain or to decline to cast your stone, to put your stone down. Not in the sense that the person is, again, on a more equitable, nuanced analysis, not guilty, nor in a sense that they deserve mercy, but on the sense that you are not in the position, as the party exercising judgment, to pronounce one way or the other. Maybe somebody else would be, maybe a divine figure would be, and in fact, as it relates to the Christian tradition, this is a rich sort of trope and idea that we are not to stand in judgment of one another in certain respects, in part because God will, or that there is sort of a different kind of judgment coming. But that whatever the exact backdrop of it is, that some evaluation has to be given to whether foundation for judgment exists, and that is the thing that an automated decision-making system, even if it replicated human intelligence or human cognition in other respects, would not necessarily be capable of, because the success of that operation, or the sense in which the decision about whether one has good grounds to judge is successful or not, or is satisfying or not to the affected party and to the world and to the agent himself, is not something that can be reduced to the manipulation of information in any kind of non-contextual way. So, of course, all problems are informational problems at some level of generality, but there's a sense in which what one is called on to do, or what I would understand this parable in John 8 to be sort of talking about, or the way I'm interpreting Christ's admonition to consider whether one should cast a stone or not, is to introspect and think about one's own kind of moral, psychological situation vis-a-vis the other party and the conduct that they are accused of, and decide whether, as a matter of individual conscience, or as a matter of sort of individual moral psychology, judgment seems warranted. And I think that question by its nature has no abstractable answer. So it's indeterminate. It does not give us nothing about this operation. It is meant to kind of give us an algorithm of any sort about whether we do indeed in any given context have good grounds to judge or not. The point is not to say that we don't. It's simply to say that that's a hurdle that has to be cleared before judgment can be authorized, or might say before judgment can be carried out in a way that is sort of satisfying or kind of legitimate in ways that we've traditionally thought is required for the maintenance of a kind of a just, legitimate legal order. So that's the idea. I think I'll end there, and I'm sure there will be some questions, and I look forward to them, and we'll get into some concrete examples through Q&A, and but hopefully that gives you a little bit of a sketch of the terrain that I'm working in here.